Okay, now we'll move over to Chris King to say a few words.
Yes, hello, and welcome to everybody who's attending, to our hosts and co-hosts, and to our members and non-members, and very much to Charles Oppenheim, to whom I will return in just a moment. I'd like to remind you, please, to use chat for questions, and chat questions need to go to everyone, otherwise I don't necessarily see them. We will aim to be through the meeting in about an hour, perhaps a little bit less, and then we will conclude. And I'd like to make sure that everybody's muted. Yes, you are. So I think we're ready to introduce Charles, and those of you who were paying attention would have seen on the opening screen that he's a visiting professor at Robert Gordon University in Aberdeen, though he used to be in Loughborough. So I guess moving to Aberdeen is a move up in the world in many ways. He's published an enormous number of journal articles and conference papers, reports, books and book chapters, and shortly, recently, his co-authored publication entitled Information Law Compliance for Librarians, Knowledge Managers and Information Professionals was published by Facet. And I'm told by Nicola that it's a very important book and a very good read. You're very fortunate here this afternoon because I've been looking at Charles's previous presentations here and there, and you could be getting copyright in a post-Brexit world for £50. So congratulations on making a good choice. Charles, not only an expert on the subject, but a good friend of all of us, the floor is yours. Thank you very much indeed.
Thank you very much, Chris. Can my first slide be put up then?
Charles, do you want to share that?
Oh yeah. Sorry. Yeah, quite right.
Speaker to share PowerPoint, it says here.
Yep. Can everybody see that? Yep. Very good.
Thank you.
Okay.
Yes, I can see it.
Good morning, good afternoon, good evening, based on wherever you are, and welcome to this event, which was organised by Nicola. So thank you to her for the invitation in the first place. How do I advance the slides?
Just as normal, just click on it.
Yeah, sorry. So these are the things I'm going to cover today. I'll do a bit about copyright basics. I'll give you a passing mention of other intellectual property rights of relevance to Philately. I'll then get back to copyright, talk about copyright ownership, copyright assignments and licenses, infringement of copyright, and how you can get away with infringing based on exceptions to copyright. I'll talk a bit about the problem of orphan works, which is particularly acute in Philately. I'll talk about some of the particular players within the philatelic world and how copyright affects them, including, of course, all of you. I will mention my risk equation, which you should all scribble down when it comes to the point. Give a few thanks as well. But please note the final bullet point. I'm not a lawyer and therefore can accept no responsibility whatsoever for any actions you might take or choose not to take as a result of this talk. In other words, when you get sued for infringement, there's no point in saying, well, Charles Oppenheim said it would be okay, because the judge will just ignore that. Sorry about that. So this is my take on it all. This is a late 19th century advert, and it says copyright will protect you from pirates and make you a fortune. So that, I hope, is indeed the case for some people. The question that I will answer as part of this talk is it okay to reproduce the images in the next 3 slides? So if you'd just like to glance at these images, they're familiar enough, but am I breaking the law by putting them up? And that I will answer. But let's go to the copyright basics. First thing to say is that it is absolutely automatic. You don't need to register anything, and there is in fact no requirement for a copyright symbol, but I'll come back to that in just a second. But the crucial thing is it's automatic. As soon as you create something, you have got copyright in that creation. Now, some countries' stamps include a copyright notice on the stamp or on the selvage. It's not necessary in most countries. There is one exception though, which is the USA. In the USA, it is necessary to put a copyright notice on stamp or whatever it is you're creating if you intend to sue for infringement, if you intend to get someone who has infringed. Not necessary in any other country in the world. So it is just in the USA. So the copyright comes into existence as soon as you create something new, that is to say, not copied itself. And it is fixed. In other words, it doesn't vanish without trace instantly. So fixed, there's no precise definition, fixed, but if something literally flashes up for 1 second and then vanishes, nobody's got proof that it ever existed, then it isn't a copyright item. Copyright can apply to words, to images, to moving images, to sound recordings, like the recording being made of this particular event, dramatic works, that's plays and so on, broadcasts, and various other things. Though obviously I will be focusing primarily on text and images. There are also moral rights. I'll come back to that in a little while, but when you create something, you have the right to be identified as the creator and the right to object to any derogatory treatment of what you created. We'll come back to that, as I say. Moral rights are related to copyright, they're not identical. The lifetime of copyright, and indeed of moral rights, is normally 70 years after the end of the year that the creator died. But some countries have different rules. When the creator does die, copyright typically will automatically pass to their heirs and successors unless they've made some specific statement in their will that their copyright should be passed to somebody else or some organization. Anything that is published that is really old, say pre-1900, is probably out of copyright, therefore, because the lifetime is 70 years after the end of the year the creator died. And so you can do what you like with it. But unfortunately, published isn't precisely defined in law, but it certainly doesn't just relate to formal publishing, like a book being published or a magazine being published. To be published, it has to be made available to the public or a reasonable sized subset of the public, maybe for free, maybe for nothing. That will be considered to be published. And that will include stamps, printed ephemera, old catalogues, postmarks, etc. So those are certainly published items. What about unpublished items? Well, they can include things like manuscripts and letters. Now, a letter may well have gone through the post and gone from person A to person B, so 2 people have seen it, but that doesn't make it published. In order to be published, the intention must have been that members of the public could look at it. So these sorts of things, manuscripts, letters, and so on, their copyright lifetime can and often is much, much longer than the 70 years I just mentioned. And so you need care when dealing with them. And I'll come back to this topic when I talk about orphan works, which are the big deal in philately and is a potential problem for people wanting to reproduce manuscripts and letters and so on. So what if you take a photograph of an out of copyright work, say a penny black stamp? Do you get copyright in that photograph? The answer is no, normally, because you haven't used your skill or creativity to create that photograph. So the only times that you would get copyright in a photograph is that you could demonstrate that you use skill and creativity, like perhaps careful lighting or photographing the thing at a particular angle to highlight a point, something like that. So by and large, a photograph of an out of copyright item doesn't enjoy its own copyright. Here's an example of copyright notice on the stamp salvage. It's the United States Postal Service. It's actually a used thing from my collection. But what's significant is that if someone reproduces this, and I have, and I'll give you my explanation in a little while, if somebody reproduces it and the United States Postal Service wants to sue for infringement, the fact that it had that copyright notice on the sheet would be enough for it to establish its rights. But as I say, there's no need for that sort of notification in other countries. So what does copyright give the owner? The owner of the copyright has the right to prevent any third party from reproducing, distributing, renting, in other words, for money, lending for nothing, or performing or communicating, say by electronic means, or amending or translating the work without permission, which sounds pretty terrifying, but we'll talk about exceptions to copyright in a little while. If you do such a thing without permission, you've infringed the copyright and can be sued by the owner, and that would be for financial damage. Or if you've done it deliberately to make money, you've copied something and you've been selling that copied item, you could be prosecuted by the state, and that applies to most countries in the world. Now, just because you own something doesn't mean you own the copyright in it. So you own the stamp, the cover, the artist proof, the book, the journal article. It's in your collection, but you don't own the copyright in it. The copyright will belong to whoever created the original item or to whom it was passed, the copyright was passed. As I mentioned before, there are moral rights as well. I've already indicated that the creator is not always the owner. I'll come back to that point in a little while. But in the case of moral rights, that is to say, failing to credit who created the item, amending the item in such a way as to diminish the reputation of the creator, it's the creator, not the owner, who can sue. So that's a separate right to sue for derogatory treatment or failing to credit. A couple of other intellectual property rights you should be aware of. I'm just going to skip over them. Registered trademarks can be important, particularly for catalogue publishers, postal authorities, auction houses, stamp dealers, and so on. And database rights might be important to catalogue publishers, which I'm now going to come on to. Stamp catalogues are a particular problem. A simple fact like SG catalogue number 1 for Great Britain is a penny black, price used is £525. Those are facts and they have no protection whatsoever. Simple facts never have copyright protection. But a collection of facts might have copyright protection if, and this is the wording of UK law, similar in other countries, if the collection is original by means of a novel selection or arrangement. So, arranging stamps in a catalogue in date order and then face value order for each issue with a catalogue number in numeric order is so obvious that it has no copyright protection. But a thematic catalogue, where the creator of the catalogue has said, yes, this falls into that theme, that doesn't, or some specialist catalogue with lots of commentary, would be protected. And there may be database rights, which I said I would mention. Not all countries have this, but every country in the European Union, including the UK, does have database rights. A database right is something different. It is if the catalogue publisher made a substantial investment in obtaining, verifying, and presenting the contents of the catalogue. And note that it's the obtaining and the verifying and the presenting which is important. So the fact that the catalogue costs quite a lot of money to the catalogue publisher to print and publish is irrelevant. The real question is, did they make a substantial investment in obtaining, verifying, and presenting the contents? Personally, I'm doubtful that there's any copyright protection for the major country-based catalogues. Interesting court case which was drawn to my attention originally by Chris King, between a German catalogue publisher, Michel, well known, and a German book publisher. And the question was whether a book could cite the naming conventions of a Michel entry, the equivalent of SG 71, if you like, on Stanley Gibbons. And the court apparently found in favour of the book publisher rather than the catalogue creator. The argument was that the catalogue numbers were just in incremental sequence without any inherent value added. I'm trying to find details of this case. They're proving to be remarkably difficult to get hold of. But if accurate, that merely confirms what I said in the previous slide, that catalogue publishers have relatively little protection in terms of copyright. And that despite statements they make, which I will come back to later on. Now, I promised I'll tell you about ownership. Normally, the creator is the owner, but if that person made the creation in the course of their employee duties, then the employer automatically owns the copyright. And that's true in virtually every country in the world. So if you're an employee, say like Nicola, and she produces something relevant to her work on behalf of the Royal, then automatically copyright in that work will belong to her employer, the Royal. But if you're a sort of freelance or semi-independent and you created it as part of some commissioned piece of work, then it depends on the commissioning contract. So that's relevant to artists, designers of stamps and first day cover artistry, and indeed, I suspect virtually all stamp issuing authorities will be commissioning things from third parties. So, in those circumstances, it just depends on the contract between the two. And it could be that the original creator owns copyright, or it could be that the person who creates, the organization who commissioned the work owns copyright. What about if you as a philatelist create your own text or images for an article or for sheets in a display? As long as it's not copied from somewhere else, you will normally own the copyright in what you created, unless it's just simple facts like this stamp is SG21 and this stamp is SG46. Now, the owner, let's just say it's still the creator, can, if they wish, choose to assign the copyright to a third party or to license, that is to say, give permission to copy while retaining copyright for themselves, a third party to do things with their creation. And indeed, I signed a deal with the Royal regarding the creation of this PowerPoint and of my presentation. So I was happy to do this transfer. Now, the creator might choose to charge for such things, but are not obliged to. And indeed, I have not charged the Royal a penny for generously giving them this PowerPoint. I presume, I don't know, but I presume the catalogue producers have obtained licenses from the stamp issuing authority to reproduce images of in-copyright stamps that they reproduce. Joint ownership is always possible if more than one person was involved in the creation. So if you take a stamp, a postmark, etc., blow it up to show a particular feature, and you use skill and effort to do that, you may well own copyright in your new image. But at the same time, oh, there's the word missing, time, at the same time, you might infringe copyright in the original. And that sort of situation is not at all uncommon in copyright law. So you've created something that is your copyright, but you've done it based on something which is somebody else's copyright, and you've not asked for permission. So you get this rather curious situation that you own the copyright in your image, but you may well have infringed somebody else's copyright. Rather helpfully, there is a piece on Wikipedia, or Wikimedia, I should say, regarding the copyright of stamps in all the major countries of the world. It's aimed, this particular listing is aimed for those people planning to reproduce images of stamps on Wikipedia itself, but it's also useful to anyone who wishes to reproduce stamp images in any context. So that's something to take note of, and maybe when we come to the recording of this and people want to refer back to it, they can do so. Making a simple copy of a stamp, postmark, etc. without any particular skill or judgment involved will not, as I said before, give you copyright in the image, and it might infringe the copyright of the original. Okay, I've given you all the bad news, now let me give you some of the good news. The law allows activities which would otherwise be infringement to be done without having to ask for permission or pay for any fees. And there are quite a list of them, but the ones most relevant to philately is copying an item for non-commercial research or private study. It must be non-commercial, so if the purpose is for research for a book or report, which is going to be sold, you anticipate it'll be sold, then this exception does not apply. So you might be infringing. So it's for your own private research or private study. Copying an item for criticism or review. And note that there's nothing about commercial or non-commercial here. It's for any criticism or review purpose. Now, you don't have to be criticizing the item which you're copied, but you might copy something to highlight a criticism of something else. And criticism or review is interpreted generally, and review implies book reviews and things like that, but it could be other types of review as well. Copying for non-commercial educational purpose. Now, this talk is educational. At least I like to think so. And so I am okay to reproduce stuff like all those stamp images I did earlier as part of this talk because it's educational and I'm not making any money out of this, and nor indeed is the Royal making any money out of this event. Auction catalogues have got a specific exception. They explicitly allowed in law to reproduce materials in the catalogue, auction houses. And I would argue this extends to online services like Delcamp and eBay. And then philatelic libraries and archives have all sorts of permissions. They can make copies of items held by the library for their patrons. So if you go to the library or ask the library for a photocopy of an item or a scan of it, for example, that's perfectly okay. Libraries can also allow their patrons to do self-service copying. Once again, there is no problem with the library granting you permission to do that, but you have to make sure you do your copying legally. And as I say, also scanning, copying materials for preservation or archiving purposes. If you do go to a library and ask to make a copy, or for the librarian to make a copy for you, there is a standard wording which you have to sign, promising that you're going to obey copyright law with the copy. Libraries working together to share digitizing workloads or digitizing materials belonging to somebody else on an exchange basis is almost certainly okay as well. Now, I mentioned orphan works. Definition of orphan work is something that is still in copyright, but the creator or subsequent owner is unknown or untraceable. An awful lot of them in Philately. Unpublished reports, private letters, which, as I said, have very long lifetime. Recent publications, but with unknown authorship or provenance. Some countries, including the United Kingdom, have laws that permit the use of such works by means of paying a license fee to a centralized service, which will then pay to anyone who comes out of the woodwork, saying, actually, I own this. But it's very limited, the permissions which you're granted. And some countries also provide for an exception to copyright for orphan works under very restricted conditions. Unfortunately, for a lot, probably the vast majority of cases, you may not be able to take advantage of such schemes or exceptions for the purposes that you want to get access to or to copy an orphan work. So this is a typical orphan works problem which was drawn to my attention recently. Specialist Philatelic Society folded. Someone would like to reproduce articles from its now defunct magazine in their own magazine. It's not clear if those articles' copyright were owned by the authors or the society, because there are no records remaining of whether copyright was assigned to the society or not. And there's no one to approach. The society has ceased to exist, and there's nobody handling its affairs. So what do? It's a typical example, and you could think of many further examples, like you have a letter, a bit of private correspondence, which is still in copyright. You'd like to reproduce it, but you don't know who to ask. You need to make a risk assessment, and I'll come back to that later. Okay, let's have a look at impact on some players. For catalogue publishers, they have little protection in their country-based catalogues, and their statements about this, which I'm going to come on to, are misleading. But they do have trademark protection, so you can't call yourself Stanley Gibbons or Michel or whatever. For those of you who display items, you normally will have nothing to worry about. But do be careful when reproducing maps and photographs, if those are what you're going to be using. You will own the copyright in any original text or images you have added, and quite possibly in the selection and arrangement of materials on sheets. And you may be able to argue that any copying or displaying is for educational purposes. So you should be okay. Slight problem if you are in the running for a medal or something like that, because that possibly could be argued is for commercial purposes, but nobody's tested that, and I would think the risk is probably very low. Author of the philatelic books and articles must ensure third-party material you reproduce is either so old to be out of copyright, but remember about unpublished works, or you have permission from the copyright owner, you've actually written to them and asked for permission, or their use falls under an exception to copyright. But as I say, with orphan works, you might have to take risks. But don't just assume it'll be okay. Your writings themselves, unless you've copied from somebody else, will be your copyright. Publishers must ensure anything they reproduce is clear of copyright problems, and they typically, and quite rightly, require submitting authors to confirm that nothing the author has supplied will infringe copyright or any other law. And they may or may not require the author to assign copyright in the text submitted to them. Got to be careful, publishers, of not infringing the author's moral rights, that is to say, to not change the text or what have you without permission in a way which is derogatory, or not acknowledging who the author was. Any not-for-profit philatelic organisation that scans materials for preservation purposes should be fine, but any scans, whether it's a philatelic organisation, a library, or what have you, which puts scans on the web and thereby is further disseminating it, that is potentially problematic and has to be done with care. Pre-printed album pages will often be copyright. Digitizing your personal collections of articles, philatelic material, perhaps for insurance purposes, might in theory be infringement, but as long as it's not further disseminated, you should be safe. So here's a Stanley Gibbons statement. Content of this catalogue, including the numbering system and illustrations, are fully protected by copyright. No part of this publication may be reproduced, stored in the retrieval system, or transmitted in any form or by any means without prior permission. That's misleading. For starters, they take no account of exceptions to copyright. You can copy bits as you see fit, as long as it falls under one of the exceptions to copyright. For example, for educational purposes. And that's why I'm able to reproduce that statement from the Stanley Gibbons catalogue, because I'm doing that for educational purposes. In any case, I believe, as I've indicated before, that there is no copyright in the catalogue. However, and this is a quirk of copyright law, it is not illegal to claim something is your copyright when it's not, or failing to draw attention to exceptions to copyright. None of that is illegal, strangely enough. Nonetheless, I would argue that publishers like Stanley Gibbons should insert the words, except as otherwise permitted by law, no part, la di da da. But they're not obliged to. Okay, digital issues, something posted on the web can get widely disseminated at little or no cost, and therefore you need to be careful, because the more something is disseminated, the greater the potential infringement is. Copying and archiving websites and electronic materials is normally only allowed for certain libraries and archives, including, for example, those of the Royal and also national libraries and archives. If I, as a creator, am not concerned about other people reproducing my materials online, on the web, then typically that person would apply a so-called Creative Commons license, which says in effect, I retain the copyright, but feel free to reproduce this and I won't charge you. Several types of Creative Commons licenses, and there's the URL if you want more details about Creative Commons licenses. Furthermore, Creative Commons service offers a rather crude search function to identify stuff which is Creative Commons licensed. And so if you go to that www.search.creativecommons.org and type the word in Philately in the search box, you'll see the sorts of images you can use free of charge. And here's just a couple of examples taken from that, just to show. Right, nearly at the end of my talk. I have always argued that copyright is much more to do with the management of risk than details of the law. And this is my wonderful calculator, which I've used for many years, or recommended to people for many years. Let A be the chances that what you have done is infringement. You decide. Are you absolutely confident that this is not infringement? Well, then you put a 0 in. If you're pretty certain it's likely to be infringement, then you would put a 1 or perhaps a 0.9. Let B be the chances, again, between 0 and 1, that the copyright owner will find out that the infringement has occurred. So, for example, let's say you have copied a valuable item which you happen to own, and you've digitized that copy for insurance purposes. How will the copyright owner find out that you have done that? It's very, very unlikely they'll ever find out that you did that digitization. So you could put a very low figure on that. And let C be the chances that, assuming they have found out, the owner will sue. Again, between 0 and 1. Basically, it may well not bother if this is a minor thing, but very likely will bother if you really damaged the copyright owner's financial or other interests. And let D be your guess of the maximum penalty that's likely to be involved in pounds, euros, dollars, choose your currency. And that almost certainly would be the financial damage caused to the copyright owner plus legal costs that you would have to pay. Then if you multiply those 4 figures together, A times B times C times D, you'll get a figure. And that might be, say, £1. You end up that your risk is £1. Then it's up to you to decide whether it's worth taking that risk or not. So consider how risk averse you are or your employer is. And if your employer, and you're doing it as part of your employee duties, whatever it is a very high profile organization like a national library or like the Royal, with a reputation to protect, just imagine how embarrassing it would be if with the publicity it demonstrates that this particular organization has blatantly infringed copyright. Then that organization will be very risk averse. On the other hand, if it's just you privately and you could live with the sort of figure that you've calculated, well, go ahead and take the risk. It all depends how risk averse you are and how accurate A, B, C, and D are likely to be. But you could be quite conservative about A, B, C, and D. And try to work out the worst possible scenario and then see what figure comes out. I'm not going to tell you what figure is the break point. That's up to you to decide. But it helps you decide. It helps put into context what you're doing. Final couple of slides. This is a newspaper article, how an instantly iconic Newfoundland iceberg became a Canada Post stamp. Reproduction of the stamp there and an article associated with it. Copyright in the text of the news story, which I haven't reproduced in full in that previous slide, is owned by the Canadian Press. The freelance photographer, somebody called Michael Windsor, owns the copyright in the initial image, possibly assigned it, or perhaps more likely licensed it, to Canada Post, no doubt for a fee, to reproduce in the stamp. Stamp is more than just a photograph. It has design elements which were probably created by Canada Post employees, and so those parts are presumably copyright Canada Post. Stamp itself has a C2018 added, but it doesn't specify who the copyright owner is. Maybe it's Canada Post and Mr. Windsor jointly. And as I've indicated, there's no need in Canada to have such a copyright notice anyway. So I've chosen to reproduce that slide, that previous slide, under exception for criticism and review and or non-commercial educational purposes. So I'm fine, but it's just an example of an article which has quite a complicated copyright features. So that's my talk. I've been talking 40 minutes. There's my email address if you want to follow up after the event with questions, hypothetical situations, real life situations, and I can comment on them. My thanks to Nicola and to Mike Hoffman for help and encouragement. This PowerPoint is my copyright, but I'm happy for you to reuse it, any of you in the audience, as long as you acknowledge me. In other words, my name appears somewhere. So that is me done. So I'm now happy to respond to any chat questions which might exist. And I can see there are some. Chris, are you going to sort of lead on the chat questions?
There we go. Yes, I'm going to deal with the questions. I actually wrote some questions myself because I thought the audience was very silent at the beginning, but now we've now got quite a lot of questions. So this is from Nigel Prenter. At independence, did Crown copyright on postage stamps pass to the independent countries, in particular Fiji, Kiribati, Tuvalu and Vanuatu? If so, does UK law re-Crown copyright, or the independent countries' copyright laws apply? That's part one. There's a part two.
Okay, well, if I could comment, I have no idea what the arrangements were for independence of a particular country. That will have been in whatever the independence law would have said. And it could be that the copyright, which had been Crown copyright, then got transferred to the government of Fiji or whoever else it was. But, and thank you for the question, because it's worth stressing, if you're doing something in the United Kingdom, it's UK copyright law which applies. So, so even if the law in the other country says you can't do this or you can do that, it's irrelevant. It's in the country that you're doing it that counts.
Okay, thank you. And another sort of subsidiary question also from Nigel. Is enlarging the image of a stamp shown in its entirety with permission to use okay?
Sorry, with permission?
Yeah, that's what it says. But let's just take it as Nigel.
Yeah, I'm saying I already have got permission to use various stamps from British Overseas Territories. But the stipulation was in their entirety, which I presume means you don't sort of start taking bits of a postage stamp. However, supposing you want to, you know, amplify it, but bring it up in size, do you think that's all right?
I would have thought that was all right as long as it's still in its entirety. So in other words, so you've blown it up so much that you've cut off part of the material, then you've breached the license that they granted you. But by all means, blow it up so that you know, an A4 size when it was originally just a stamp size or something like that. Yes, that will be okay.
Thank you very much.
Remember, he's not a lawyer.
Yes.
Okay, this is from Roger Johnson. He writes, I thought that reprinting a copy of a current SG catalogue in the Far East and selling the book for 50% of the UK price would be a breach of Stanley Gibbons' copyright in the published work. Is that right?
Yes, that almost certainly is infringement for a couple of reasons. First of all, their trademark will appear almost by definition all over the place, and that's an infringement of their trademark. But also, this is even though what I said was they don't own the copyright of the whole work, if you do a great big chunk of it and sell it, that is infringement, I'm afraid. So the sorts of exceptions to copyright are non-commercial exploitation, not commercial exploitation.
Okay.
So I don't recommend it. And if you do get sued, I'm not prepared to act as a defense lawyer.
Or even as a a specialist advisor.
Either, indeed.
A question from Malcolm Groom. Are journals produced for members as part of their subscription being produced for a profit?
That's a really good question. And that's why this term non-commercial versus commercial is really very awkward. I would perhaps argue, I mean, I think in the case of the Royal, if you, correct me if I'm wrong, but I think one of its objectives is the education of its members. And therefore I would argue that there is an educational purpose to the creation of these articles and so on, and journals, and therefore it should be okay what it's doing. But I do acknowledge that that it's a grey area.
Yes, just so you know, Charles said to me that copyright law has many grey areas. I've got a question here from John W.B. Spencer. If, through my research, I found an unrecorded variety of a stamp and later published the result of this research in a paper, monograph or book, would I own the copyright of that research?
You certainly own the copyright in the description of what you've done, so the writing. You wouldn't own a copyright of the image of the particular variety because just because it hadn't been noticed before. That the original copyright would be still with the post office that created, or the stamp issuing authority that created that. If you blew up the image to home in on the particular feature of the variety, which you may very well want to do so, then you could argue that that is okay for the purposes of research, private study. But I would just hesitate a bit, because if it is for a monograph which is being sold and you intend it to be sold, then it becomes problematic. So an article in a periodical, yeah, that should be okay. But for a book, a monograph which you intend to sell or publisher intend to sell, and you know it's going to be for that purpose, you really would need to get permission somehow.
But it's only problematic, Charles, if the number resulting from the Oppenheim risk calculator
Yes.
is greater than you would find acceptable.
Indeed, very true.
Right. Okay, this is from Abhishek Buwalka. Can one go to the library and get an entire book copied? Will fair usage rules not apply?
Yep. Yes, as I indicated, library will require you to sign a piece of paper, and part of it will say things like no more than 5% can be copied, or no more than one article from this periodical can be copied. So there will be limits put on you, and indeed, question is absolutely right. These exceptions all rely, or some of these exceptions rely on the concept of fairness, and fairness means not damaging the legitimate interests of the copyright owner.
Fine, thank you. This one from Kim Stuckey. What if you use an original press photograph that you've brought from a photographic library? Can you use that in a published work?
Not necessarily. Just because you own it doesn't mean you've gained copyright or copyright permission. So it all depends. If you bought it from a commercial outfit, there will be terms and conditions about what you can do with it and what you can't do with it, and they will be pretty explicit. You've got to abide by them. And if you want to do something that isn't on the list of things, you've got to go back to the organization that owns copyright and say, I want to do this, is it okay to?
Right. Curiouser and curiouser, eh? Harold Krieg asks this one. Can a society republish their past journals, for example, in a digital format, without asking the authors for further permission?
It all depends whether they got copyright in the materials in the first place from the author. So if the author has assigned copyright to the publisher, to the journal publisher, then the journal publisher can do what it likes. If, on the other hand, the author merely licensed the journal, publisher, then it depends on the precise terms of the license. May have to go back to the original author and say, we're planning to digitize this, is it okay?
Right. And another from John W.B. Spencer. Who owns the copyright of a piece of private correspondence? The writer or the recipient?
The writer.
If that piece of correspondence is sold by the recipient, does the purchaser own the copyright?
No. So as I said at the start or early on, just because you own something doesn't necessarily mean you own the copyright. So if you buy a piece of correspondence, you almost certainly do not acquire any rights to reproduce or any copyright in it. And if you want to reproduce, you need to track back to who the original author was, the creator.
Okay, Tony Plum. Book publishers often claim they have the copyright of the layout,
yes,
even when the copyright of the text is vested in the author. In Philately, are the layout of a page and separately the text on that page covered by separate copyrights or joint copyright?
It will be separate copyright. So the layout, which means typography, spacing, the way headings are presented and so on, that will belong to the publisher. Who owns the text depends on whatever the deal was between the author and the publisher.
Okay, yes, from Kim Stuckey. If you use a photo from the internet from a site where the owner says they copied the image but couldn't find the originator, have you copyright issues?
Yes, that's a classic risk assessment. Apply my formula.
I refer you to the ORC. Abhishek again, can I reuse your PowerPoint, Charles, for non-commercial educational use without acknowledging you?
No, because you'll be infringing my moral right to be identified as the creator. So feel free to use the PowerPoint for educational use as long as my name appears, which appears in, I think, the first and the last slide. So don't delete those.
Right, and from Gordon Hardy, are maps covered by copyright in the same way?
Yes.
With a book, you're able to copy 10%. Is it the same for a portion of a map used to illustrate a location of a village or a town? With digital maps, data such as coordinates taken from, say, Google or Ordnance Survey to illustrate changes of routes for mail carriage?
Interesting question. The maps will be copyright typically of the mapping agency, like Ordnance Survey in the United Kingdom, until they're so old that they're out of copyright. And if we're talking about changes to postal routes, then it could well be that we're talking about maps which are ancient and therefore out of copyright anyway. You can reproduce them. Google coordinates are quite an interesting extra point because it is a fact that this particular place has the following coordinates. That is a fact, and there's no copyright in a fact. But if you've got a group of these coordinates, then there's likely to be a copyright in that particular collection of coordinates. Who owns that collection of coordinates is a really interesting question. And what I would like to suggest is that perhaps if the questioner could email me subsequently to give me some more information, I'll try to comment further on that particular point.
Okay.
Thank you, I will do that.
Okay, Gordon. Great. Guillermo Gallegos, I would like to reproduce an image from a Christie's catalogue.
Yeah.
Christie's told me that their copyright on the item ended when it was sold. I have not been able to trace the current owner. Can I ask Christie's for the authorization to use the photograph in the auction catalogue?
Well, first of all, I'm really intrigued that Christie's say they no longer own the copyright, because I presume it was a Christie's photographer who took the photo. So I am really puzzled by that. I don't know enough about how auction houses operate, but it may well be that they negotiate with the owner of the original object, whatever it is, and say, we will reproduce this in our catalogue, but thereafter the image reverts to you or to the new owner. So I don't know enough about the way that auction houses operate, to answer comprehensively. But I really would query Christie's statement that they no longer own the copyright. Very, very odd. I would have thought in any case the risk would be quite small, but that's another issue.
Mark Bailey, you've got a supplementary.
No, I've got a comment on that, if I may, Chris. Thank you. And Charles. This business about auction houses and the images that they have that they use in their auction catalogue. I contacted Spink a couple of years ago, doesn't matter when, a couple of years ago. I asked them whether they would be happy to send me digital copies of the photos that they had used to, to advertise the material that they were selling at the time. And in fact, it wasn't just in one sale, it was in a number of different sales. And at the time, Guy Croton was working for them, and Guy said, yeah, that's fine. I'll get our technical people to send them to you. And either explicitly or implicitly in my communication with Guy, I was saying, because I want to use them in a book that I'm writing. And Guy said, yeah, that'd be fine. So in that respect, I think what he was, what was manifesting there was that he was acknowledging that Spink had copyright in their own images, and he was allowing me to use those images.
That's helpful. Thank you very much. But possibly Christie's have a different policy to Spink. Who knows?
Indeed.
Okay. Move on. We're going to break our hour, and I'm going to carry on because we've still got 56 present and we've still got people asking questions.
Right.
Who owns the copyright for articles published in the London Philatelist? And before Charles answers that, can I bring Frank in, please? Frank Walton.
Can you hear me?
Yes.
Yep.
It's very clear. As far as I'm aware, the author retains copyright in the LP article, images exactly as per the previous comments, but the Royal does retain copyright in the layout.
Yeah.
Now, funny enough, there was a case, the guy's now dead, so I can quite happily talk about it. Gary Granzow, when he wrote his book, which the Royal published a few years ago on line engraved materials, he was being very difficult about signing the author agreement with the Royal, and he wanted the right to republish the book after so many years. I think it was after 5 years. And we said, okay, that's fine, because he actually pointed out he owned the copyright. But we very carefully agreed to that, because otherwise the book wouldn't have got done. In the front cover, it also says copyright of layout retained by the Royal Philatelic Society, which means that he couldn't just take a photocopy of the book and get it reprinted and rebound. What he could do was get another typesetter to reset all the words. Yeah. And that is the case in the LP. Yep. While I've got the microphone, can I just comment on Mark Bailey's point? I've asked that question many, many times, and all auction houses, I've never been refused, all auction houses have said, yes, you can reuse the image, but please put reproduced by permission of. Yeah. Yes. Just given the acknowledgement.
Yes.
Yep.
And finally, I think Christie's is now owned by Spink, so I'm not quite sure how the
All right. Okay. Charles, do you have anything to add?
No, that sums it up perfectly.
Fine. Thanks very much. Just running on through these, John Copeland says that it's worth mentioning that normally Crown copyrights only last 50 years.
That's correct. So? Yes, that is correct. Yes. Thank you. That's a good point. I should have included that.
Michael Hood, can an author freely use images of covers or stamps from auction catalogues or from the internet?
Well, we've kind of answered the question regarding auction houses. Regarding stamps on the internet, check whether they're Creative Commons licensed or not. That's the crucial thing. So check whether there is a CC on it. You can find it on the metadata, if need be, of any image you find on the web. If there isn't a a Creative Commons license, then you've got to ask for permission.
Fine. Roger Johnson, again. Charles, what would your reaction to someone, what would your reaction be to someone adapting your slide set but leaving your name on the slide, leaving your name on it?
It depends what they do with it. I can sue for derogatory treatment if they give a misleading or poor impression of what I said. So moral rights don't just apply to having my name there, it also applies to derogatory treatment. So, but if you actually improve my slide set, for example, by saying, oh, by the way, Crown copyright lasts 50 years, that would improve my slide set, I would be perfectly happy with that. So it all depends. But if you reproduce my slide set and put in brackets, what a stupid thing to say, I would regard as derogatory treatment.
Thank you. And one from Frank again. What is the equivalent of the 70-year rule for corporate authors?
If it's a corporate author, like an organisation, it will normally be 70 years from the date of publication.
Okay.
Chris, can I just ask a supplementary very quickly on that one?
Mm.
The books that the Royal publishes, very often it says edited by.
Yes.
There's been some recent examples of that. So Charles, how does that relate to what you've just said about corporate authorship?
Well, that could apply to the book that I edited.
Indeed, yes.
It depends exactly what is meant by editing, but in my case, it was the particular authors had drafted something, I suggested changes to it, which the author then made, and then the thing was submitted to the Royal, and we'd have the standard Royal contract. And I created Medford's introduction. I wrote a bit, which once again was subject to the standard Royal contract. So it doesn't really make any difference. The editor, arguably, is just another contributor, and therefore it depends on the contract of the editor with the particular publisher as to who owns the copyright.
Okay, thank you.
Okay, John Copeland, a very interesting question here. Bearing in mind the problem of orphan philatelic works, should members leave their philatelic copyrights to the Royal? A number of members have.
Yes, that's a really interesting question, and I would say yes, there is a plausible argument for doing that. Yeah, I mean, as I say, when somebody dies, normally automatically the copyright goes to their heirs and successors if their will isn't specific. But there's an interesting case to be made to encourage members and fellows to not just leave money in their will or whatever else to the Royal, but also copyright to philatelic related material. Yeah, nice question.
Good. Frank says the RPSL has a standard suggesting wording for such a legacy.
Oh, right. Okay.
I, for one, have already done this. So.
Okay, including copyright. Yeah. Okay. Wow.
We should obviously make it more widely available.
Yes, absolutely.
And I think this might be the last question before the one that I've been saving up. Nigel Printer, I presume British Empire stamps before 1963 are Crown copyright.
Yes, that's a reasonable assumption. Yeah.
I want to return to the question of digital auction catalogues.
Yes.
Now, a lot of auction houses give away their catalogue freely as a download.
Yep.
And let us say, for the sake of argument, we wanted to collect up all of those at the Royal and make them available for research and open them up freely for download on the internet. Would we be breaking any copyright?
I don't think so, is the answer. I really don't think so. I think it would be part of the Royal's function to do that. and it could be done through the library or through the archive as part of the service that the Royal offers. And it would actually be very useful, wouldn't it, to track perhaps the history of a particular item over the years. Yeah, I like it.
Fine. Thank you very much indeed. I think that is that's probably got to the end of the questions. That was more questions, I think, to Charles than there have been to anybody else in the series so far. And in fact, if you'd have asked me to gamble on that, I'd have said that was very, very likely. So can I say thank you very much indeed, Charles? That was largely illuminating. And I'm sure we're all better informed. Is Nicola still with us? Because she's actually at another meeting. Well, the next event is in 2 weeks' time.
No, I am still here, Chris.
Ah, you are. Would you like just to announce the next event, please?
Yes, it's 2 weeks' time. It's Victoria Stevens, who's an ICON registered conservator that did some grant funded work restoring our Perkins-Bacon delivery books. So she's been recording some footage while she's been doing that, and she's going to give a talk and describe some of the techniques she's used.
Fine, thank you very much. And that's in 2 weeks' time, but it is full, I think.
It is. You can put your name on the waiting list, and if there are no shows on the day, then we can send the link out to you and let you in.
It really has been a very, very popular one. It just says to me we need to do more, probably on copyright and on conservation. So can I say thank you also on behalf of us all to Nicola for putting this series together.
Yep.
This is the penultimate. Well, no, we've got one more after that on research from Kim Stuckey and Mike Roberts on using an archive. In fact, it's the archive in the Falkland Islands, and that's in 4 weeks' time. So, but thanks, Nick. These have been very good, and today's was, I think, extremely helpful, and there are certainly some comments and compliments coming through now. So thank you very much. What we can do is to leave the chat open, and we'll stop recording, I think. But just very lastly, Charles, really, really grateful. Thank you very much indeed. And I shall carry the Oppenheim risk calculator with me at all times.
Yeah, you can load it up on your pocket calculator, no problem.
Well, it should really be in the form of an Excel spreadsheet, shouldn't it? So you enter 4 numbers and you get the result.
Yes, absolutely.
Anyway, thank you very much indeed. That concludes the formal part of the meeting. Very happy to leave the screen open until everybody else has got fed up for open chat. Nicola probably will leave us because she actually left another Zoom meeting to attend this one.
Thanks very much as well.
Thank you, Charles.
Mike, I think we should unmute the mics if people want to unmute now. Are you going to stop recording?